Greg Ashwell for the applicant. I know that, as I said earlier, there are several constituencies in this particular proceeding. Applicant, the county, landowners who may be aggrieved. So I want to put things on the record in anticipation of an appeal from any of those three particular individual groups. So forgive me if I wax on redundantly a little bit. Comprehensive plan, principle 6-7. Comprehensive plan shall be considered by all county government agencies, commissions, boards, and authorities. Principle 1 and 2. The board, through the comprehensive plan, should encourage renewal and diversification of viticultural activities, including agritourism. This application meets this principle. Principle 3.2. You should prohibit land uses if they have a significant adverse environmental impact that cannot be eliminated or minimized. This application meets this principle. Principle 5.3. The board should ensure through the adoption or the use of the comprehensive plan that the proposed development is compatible with the architectural attributes of nearby or adjoining historical properties, neighborhoods, and districts. This is satisfied here. There's no change whatsoever in the structure that's going to be found out. Principle 6.3. The board should see to it through the comprehensive plan that it maintains the existing character of the primary and secondary road system and upgrade it, which is what I think people are asking us to do, upgrade the road system. Only for safety purposes or traffic increases planned by county authorities.
What was that plan?
Plan, P-L-A-N-N-E, plan.
Why?
The county authorities. That's a comprehensive plan, deals with who's responsible for dealing with traffic increases. What we have here as an aspect of our application is a suggestion that the applicant pony up the jack, so to speak, to improve the outflow of traffic from 211 into the Culpeper Farmers Co-op property, the neighbor next door, up Clark Lane, and things like that. Well, it really is a requirement that the board of supervisors should see that it's funded through VDOT. Now, what I found interesting about the comments was about the issue about what VDOT would like you to consider. And the last time we were here, the application was withdrawn at the 11th hour before we could get the traffic report back to a board that was considering it at the time. It was like 2 months later. I sent that to you all so you could consider. I think that addresses a lot of the issues about the traffic flow down at the bottom of the hill. Another thing we need to remember is, I think there's no less than 10 other or 12 other by right uses that would have significantly more impact traffic-wise than a 5-room B&B. That's not been addressed by the county. Principle 7C. The comprehensive plan asks its boards to investigate and initiate ways of promoting tourism in a suitable and appropriate form of economic development, and ensure that tourism-oriented development is compatible with the rural and agricultural character of the county. I can't think of a more rural and agricultural use in a small B&B right there off 211 between Sperryville and Little Washington, amongst a lot of different wineries, promoting that agritourism that we talked about. You must recognize the value of specific tourism incentives such as agritourism and the arts and astrotourism. Principle 7D. The board, through the comprehensive plan, should investigate and initiate ways of promoting tourism as a suitable and appropriate form of economic development, encouraging low-impact tourist housing. Again, this is completely consistent with that. So after we've learned that this application hits on all four of about 7 or 8 different principles of the comprehensive plan, we go to the zoning ordinance. And as -170-19 talks about use limitations. No permitted, special permit, or special exception use hereafter established, altered, modified, or enlarged shall be operated so as to conflict with the use limitations for the zoning district. Well, I mean, we had in the past, actually, another owner had a similar use there that was perfectly fine, conditioned upon certain things he did not follow through with. For whatever reason, that was up to him. And that use was then taken away. But it was good enough at the time to actually be granted. And as I look at, I think 1996, when the zoning ordinance was actually enacted, all of these things have taken place. Now, I understood from the conversations had at the planning commission, there was an issue about what is a type 1 road? Do we really know? Where is it? Well, I found it in your zoning ordinance. Article 11, private streets, 170-86, applicability, 170-87. The following types of private streets may be allowed in the following developments, provided that applicable standards set forth in this article are met. Type 1, all developments. So if you go down and you look at 170-87, it's interesting how the Board of Supervisors has used this ordinance and enacted it. We need to follow what it says. The following limitations shall apply unless modified by the board, so you have legal as a board. In conjunction with a request for a special exception, provided the applicant can show that no other remedy is realistically feasible, that plausible alternatives have been exhausted, and that not modifying the applicable limitation will place an unreasonable restriction on the use of the property, and that properties through which access is planned shall not be unreasonably affected. Now you have to look at the Park Lane. The easement right-of-way is only 30 feet between several landowners. So we're talking about not only the effect of the petitioner, the applicant, but we also have other landowners who bought their property thinking they were going to have a 30-foot easement. And it was fine back in the day when the other owner had it and got his approval. So that wasn't an issue. It becomes an issue now sometimes. But you look at type A, all types of developments. This is the important part of this. Private streets within the development shall be limited to those streets which are not required or designed to provide access to adjacent property. That's what this road is. It's designed to get access up to the top of the hill and other properties along that way. So, private streets within the development shall be limited to those streets which are not required or designed to provide access to adjacent properties, or the remainder of the tract being developed. So if you were to require a type 1 street, then you're requiring him to work with them to get a 50-foot easement. So you're really delegating the authority to approve this to people who are antagonistic to the application. So you're setting up an unreasonable department. Now there is a provision on 170-91 about ownership and care. So what you would also require, if you adopted this, without making an exception for it, is for them to agree with people that are already in disagreement about maintaining this road. Now they've already been willing and have applied to the county for a permit to work on the road, which is actually not entirely within the easement. We understand that that permit is being held up conditioned upon the outcome of this vote. We look at 170-47. Uses which would normally not be allowed in a particular zoning district may be allowed by special permit or special exception because they impose conditions and restrictions on the use in order to make it compatible with the right uses in that zoning district. This use is next with a wine tasting room, a winery in the middle of the agro-tourism sector of Rappahannock County, near the entrance to Shenandoah National Park, near the River District Art Center. So this, you would think on the application's face, is doing exactly what the comprehensive plan suggested. Now, for those who aren't familiar with the by right uses, here are some that could be just plopped up over the top of the hill without having any kind of requirement for improving the road or VDOT standards as a part of a special use permit. Crop farming, dairy farming, commercial feedlot, swine farms, poultry farm, nursery greenhouse, nursery permanent greenhouse, forestry, storage, farm winery 1, farm winery 2. All of these permitted uses could just be plopped at the top of the hill without anybody being required as a part of a special use permit to do anything about the traffic. And it just seems to me that you're treating, if you were to vote that way, treating this application significantly differently than other uses that are by right uses. Now, much of the Department of Transportation requests are offered as consideration. You should consider this. Clarify whether the use will basically function as a private 5-bedroom house or whether there be other activities. They told you they intend to make it a 5-bedroom B&B. And this is the interesting part. The highway department, through its comments to the county staff, parties with a vested interest in Clark Lane should consider approving the entrance on 211. Okay, how do you enforce that? How do you make that part of a special use permit? Okay, and he said, let's consider it. They say, no, we don't want to. Or, we want to do this. No, we don't want to do this. Well, have they fulfilled their obligation under the special use permit? The highway department wants you to force them to consider working with the farm co-op to come up with a better way to get into both properties. They want us to consider having somebody relocate the dump sign. I think I'll do that myself if it comes down to it. And consider conditions that would help ensure that there are no substantial traffic impacts. Possible place and time limit on a permit. Now, we did that the first time. After about 2 years, I don't know what happened, but that survey, that traffic engineering survey was not done. And it wasn't done again when they filed the other, back in 2019. Although they got the report within weeks of pulling their own permit, I've given it to you, and it seems to address most of the concerns that have been raised here. I know that the neighbors probably are not for this particular use for whatever reason, and they have the right to complain about the application. But if you look at it on its face, the application hits all the marks of the comprehensive plan within the ambit of the zoning ordinances. It's within your discretion not to require a type 1 road because it says it can't be a type 1 road if it serves other people, and it does. So based upon that, I've asked that you approve the application. Thank you.
Okay, Dave, Mr.
Oh, without any special riders about sunset provisions and things like that.
Mr. Staff, or does board members have any questions for the applicant?
You're aware that there's a disc golf operation up there as well as the winery.
I understand that there was some type of disc golf thing put up there, and this is the difficult thing about when I came in at the 11th hour, I got the paperwork from the planning commission, you were on that, and the reason for the planning commission sending it up to be denied was only 2 things. So the disc golf wasn't included, so.
No, I was just, I'm bringing that up just as a matter of the issue of traffic. Because you got the winery, you got the disc golf, you have the residents, and now you want to increase the traffic with adding the additional Airbnb.
I think it's just a regular B&B. I think people would be there, so. But disc golf is really not much different than tennis courts somebody might want to put in, to invite friends over to play, things like that. So there's no requirement for similar recreational uses. And it's,
I don't think that's the point she's making.
No, wait a minute. Finish over here.
I'm just trying to address the issue of the number of vehicles.
and the thing, I told them, I said, they could put, a veterinary clinic up there. You always need a good vet. And if anybody who has a dog or a cat, you go to a vet's office, boom, boom, they're in and out of there all day long. It could be 20 to 30 times the traffic generated by a B&B, yet you all have no authority as a part of a special use permit to take care of or address any of those issues with those by right uses. So any one of these by right uses would double, quadruple the traffic, and we're sitting here wringing our hands over the possibility of a disc golf course generating, and it's not like it's part of the application. It's not illegal to have a disc golf course on
No,
your
I'm not
property.
saying it is.
Yeah, and there's nothing in the application to suggest that they're going to invite people to come play or have tournaments and things like that.
Who has the deed to the property that the road sits on?
I think it's a right of way that skirts the middle property line.
Just an easement through each individual property?
Yeah, and they bought it, that already had a road, a hard surface road on it, which actually isn't entirely within the easement itself.
Not much of a hard surface left.
It's not a dirt road.
It's not a hard
But,
surface road either.
okay, well, I'm not gonna,
Well, I mean, no,
Not
somewhere
to
in
argue.
between, we can just,
Yeah.
you know, we can.
and that's what makes it interesting from this factual background standpoint. We've got our road manager here who applied and to try to get this started, to get this rectified. And the plan was sent to some regional water people who stamped it approved. And we're waiting, and the guy down there said it was approved. I don't know, the county wanted it back, it's contingent, the approval of that is contingent on your vote somehow. And we thought that's what we were.
My turn, so. I don't understand what the relationship is between some water place approving it and what we're talking about now. Is that relevant?
Well, it is because you asked a question about the road, and I said, we're trying to improve the road, we filed for a permit to do that. Got it sent from our people here in Washington to a regional water authority down in Culpeper who approved it.
Okay, so that means you're going forward.
We're trying to, but we can't do it until you all vote. They're holding it hostage. Can't work on the road.
No, we have to know what kind of work you want to do. You can't just go, oh, we're gonna work on it, it'll be okay. We need to know specifically, what are you proposing?
Well, actually, they can do that as a part of the ownership of the property. It's not a condition of,
Of course they can, but that's not my point.
I don't know what you're saying.
And first off, I wanted to try to determine who owns the property that we want to improve. Okay, do you need to?
The applicant owns the property.
Well, you just told me differently. You told me that there is an easement that goes through each other owner's property.
So there's an easement of access and egress for each property owner from 211 up to the top of the hill.
30 feet long.
And the easement implies, or actually necessitates, non-ownership of real property. It's a way to get over someone else's property. So the ownership of where the easement is kind of a non sequitur when it comes to this particular application.
Well, except that the roads we're talking about are 50 feet wide, we've got a 30-foot wide one, so I would say that's relevant.
Well, it becomes irrelevant because if you look at your ordinance, which you're bound to follow, a type 1 road cannot be required when it serves other parcels. That's what I read to you earlier, and that's our position.
What kind of a road do you propose?
The best road we can do with what we got to work with.
Well, see, that's, maybe. That's all I have. I just wanted to know what who by right had this, what the rights were to go forward.
Sharon?
Staff reports in the file, accompanied by a memo regarding road requirements, also in the file, attached to board docs. Regarding the mention to the plan review, our contracted plan reviewer for erosion sediment control is the Culpeper Soil and Water Conservation District. They have been reviewing this plan for some time, more than one submission. The county is the authority having jurisdiction to approve these plans. Yesterday, we received a notice from Culpeper Soil and Water Conservation District that the plan was in approvable form with a recommendation. So there is just a short process after that to issue the permit. So Culpeper Soil and Water Conservation District does not approve permits, they just review the plan for us, and then we process approvals. Again, we received that yesterday.
I would have a question on that, does that permit include the entrance off of 211?
No. It's actually very hard to understand what they're doing from the plan. It says there'll be no additional impervious surface on the plan. But presumably they're widening the road, but it's hard to tell. But from an erosion and sediment control plan and state code requirement, it's been reviewed and deemed appropriate relative to sediment leaving the site.
Do we have a copy of that permit?
It's not been issued yet.
There's no permit.
And it's independent of your action. There's nothing to do with your action. We're not waiting for anything. It'll be issued.
Do the other board members have questions for the administrators? Okay, we will move on to, we'll open up the public comment portion of the public hearing. I would ask that everyone limit your comments to 5 minutes, and basically anybody that wants to speak needs to be recognized by the board, and if you have questions, please direct your questions to the board, not to the outside. So does anybody wish to speak?
I do.
Good evening. My name is Randall Fort. I was a prior owner of the property in question. 2012, about 10 years ago, I successfully sought special use permit first for 2 rooms, and then that was later amended for 3 rooms. I would note that of all of the property owners on Clark Lane, only one is living there now that was living there at that time. Others have moved in during the time when special use permits were in force. For example, the Nashes, which lived one above, and the people that bought at the top of the hill. If you buy a house in the flight path of a major airport, you're not allowed to sue the airport complaining about the airplane noise because that was a prior and existing condition. So the people that have moved in knew that there was an operating B&B there during that time. I'd just like to also note that for all the questions, there is an existence proof, what mathematicians call an existence proof of what happens when there's a B&B on that property. What happens is people come, they enjoy the place, they go to restaurants, they go to art galleries, they go to antique shops, they go to gas stations, they spend lots of money in Rappahannock County, taxes are paid, jobs are created. There is no mayhem. There has never been a vehicular incident on that road involving anybody that was associated with the B&B. Zero, nada, none, null, the empty set. So for all the predictions that I heard 10 years ago, children would be slaughtered, old people would be run over, people weed whacking would be annihilated by it, never happened. Okay? There is proof about what happens when there's a B&B run on that property, and it is all positive. Carl and Donna have a track record of bringing literally thousands of people into this county at their winery next door. And without incident, thousands of people that have done exactly what I said. Buy wine, buy art, buy antiques, go to restaurants, go to other B&Bs, and bring money and traffic into this county, which is good for our economy and the jobs here. So I think, and just one point of fact, the entranceway on 211, VDOT 2014, I got the letter from them. There is no issue. There needs to be no pull-out lane. It's perfectly fine. That has been asked and answered and decided. 2014. If you'd like to have the official record from VDOT in 2014, happy to provide. Now, there are some issues on the Clark Lane. There's a curve there with trees that obstruct the view. Those were planted by the Schultzes. You can't kill your parents and then ask for mercy from the court because you're an orphan. They have created the hazard that they decry. These folks have been good citizens of the community, and I believe they absolutely deserve the support of this board and a special use permit issue. Thank you.
Anybody on the board have a question? I have one question, that when you did operate it then as a B&B?
Yes, sir.
Okay. As part of that B&B, did you have a winery associated with it and a disc golf course?
There was no disc golf course. I had a liquor license, which the neighbors also vehemently opposed. Apparently, people were going to be slaughtered driving on the road, drunk and driving. Of course, that never happened. So we were able to serve wine to the guests who visited the B&B, but we weren't operating a winery per se, no. And I think isn't a disc golf course just an amenity, like having a spa or a pool or something for somebody to use? I'm not quite sure what the objection to that is, but no, sir, we did not have a disc golf course.
Anybody else wish to speak? And please state your name and district.
My name is Yoko Barsi, in Hampton District, right above the Harmony Manor. Yes, when we bought the place, we knew there was a 3-bedroom B&B going on, ran by the forest. Yes. But our neighbors who have left Clark Lane, according to them, some of them are saying, this is a curse of Harmony Manor. That's been going on the last 20 years, or over 20 years. And staff report for this SUP application prepared by, I think, Ms. Summers, zoning administrator, has been very good, kind of concisely summarizing the history. But in that, I would like to bring particular attention to BZA minutes from October 23rd, 2013. Written by then zoning and county administrator John McCarthy. In that, this was a BZA meeting with public hearing for the courts, actually, requesting a 5-bedroom B&B. At that time, they had a 2-bedroom B&B. And the BZA at that time allowed 1 extra bedroom with a total of 3. And they said they will consider, or they will allow 2 more bedrooms if they met 2 conditions. One, to make the entrance from highway to Clark Lane VDOT approved. And number 2, to make the design of the install, what do you call it? Like past, where you can turn turnouts, where you pass the cars each other every 300 feet or so. Those 2 are the conditions for the 5-bedroom B&B. In 2013, October. Neither of these conditions have been met today. So I don't know why they should be applying for another 5-bedroom B&B. These conditions have not been met. I personally have no problems for bed and breakfast if there are no winery traffic. B&B operates up to 5-bedroom B&B, as Mr. Ford said. The entrance is approved by VDOT for up to 5-bedroom B&B. But they didn't say anything about the wineries. So that's where the traffic difference is at. And this was, not quite 10 years, but 9 years ago. And no improvements have been done. And this is way before all the road issues have been discussed. So, this was a decision made by BZA. Yes, that was, none of you were on the board at that time, but I urge you to honor the decisions made by this board 9 years and 3 months ago. Thank you. Thank you for it.
Mr. Chairman, a point of information.
No. Does anybody else in the public wish to speak?
John Capielli, Hampton District, here with you. The big elephant in the room seems to be, and I keep hearing is about the road. I already have a contract to build this new road. Mr. Curry here says that he doesn't understand it. Mr. Curry has seen the plans. We've sent the plans back and forth 6 times. Mr. Tickleman has asked a very important question about whether or not what has Culpeper to do with it. In June, when this application, a week before this application was actually filed, I signed a contract and did a preliminary design for widening the road. The roadway itself is 18 feet. We wanted to do 20 to make it wider. But the limit by VDOT is 18 feet wide. The county, separator here was also part of the conversation at an earlier meeting about limiting, a way to limit, this was brought up by Mr. Whitson at the Board of Supervisors, how to limit the wineries, and the answer that was produced by Mr. Goff and Mr. Curry was, let's put into the rules about how many people can visit. And in effect, your property would be affected by that if it was limited to 10 vehicles. And then it came to be, well, let's make it 18 feet, or let's make it wide, type 2 roadway. There have been several letters that were written back in September, I believe, by you, Mr. Macula, to Mr. Curry asking for a definition of a type 1, type 2 roadway. Mr. Curry was not able to answer those questions. But Mr. Curry is also a licensed PE for roadways. So it was kind of disingenuous that he didn't know what the answer to this was. We applied for the permit, we did our drawing, we gave it to the county, followed all the procedures, and were told that we would have it back in 4 to 6 weeks. I've done 6 revisions, we're 6 months into it, 7 months into it, and now yesterday we finally got an answer that it was being approved. Mr. Curry has just mentioned how they have a contract with the Water Resource Authority to review. There is a gentleman there, Mr. Jacobs, who is also a PE, and he approves or disapproves all driveways, erosion control permits, and things like that, and then sends it back to the county, because the county does not employ a PE to review these plans. I've worked with Mr. Jacob on maybe half a dozen different plans, and it's a real give and take, back and forth, and we're able to communicate with them. I received an email from Mr. Curry that told me I was no longer allowed to speak to Mr. Jacobs. I was interfering with their contract. Lo and behold, the Culpeper Water Resource is a public entity funded by the state. They are not a private entity. There is no contract between Mr. Curry or the county and the Water Resource Authority. they are an agency like the EPA, the FBI, or anything like that. You can talk to them anytime you want. But that has made this drag out, and that's why you haven't been able to get these answers that you've asked for at your other meeting, because it was delayed constantly by the interference of the county, with either Mr. Curry telling me I couldn't speak to them, or by Ms. Somers telling them that they could not approve this review without her permission. This is in writing. This is also going to be some taken care of in another venue. So I'm not going to go any further into that because of legal stuff. But there is a drawing that has been approved, and now, as Mr. Curry has said, they are going to issue the permit so that we can make the improvements to the road. It'll be 18 feet wide. There won't be any worries about cutouts. I've spoken to this woman here, very intelligent, she's an architect, about the preliminary designs that we had, and I've addressed them with slowing people down. People were concerned about speed on there, so we're going to put some speed bumps in there. As far as vehicles being able to go side by side, it's 18 feet. Most of the roads in this county are not 18 feet wide. They're down to 12 feet. So as far as access, traffic, and things like that, it's being taken care of. There's a contract in place, there will be a permit in place within the next few days. That should not be a consideration.
I have a question. Who is the contract with?
With
The applicant.
the applicant.
With the applicant, okay. Because what was previously stated, because that was the question that was asked, is who owns the right of way?
I can tell you all of that because I had to do the research on that. Each individual lot that runs up on both sides, their property lines come to a center line in the middle of the right of way. In fact, I've had to deal with Rappahannock Electric because Rappahannock Electric missed where their right of way was to put in an electric line underground through one of the homes. Their drawings show the electric line running down the middle of the road, of the 30-foot right-of-way. And 50-foot right-of-ways go from the center of a road out. Nobody makes a 50-foot wide roadway. It doesn't exist. So
It's the easement.
it's an easement, which was granted in 1994.
That's the right of way.
And I met with Mr. Brandon from Rappahannock Electric, and he's on the back of his truck, and he says, "Oh no, our electric line runs down the middle." I said, "Okay, but I did call before you dig, and there's the certified survey markers are out there, and Rappahannock Electric lines where your line is, and you're in that 30-foot right-of-way." He said, "Well, who put them up?" I said, "They say Rappahannock Electric on them, they're yours. Your easement."
Okay, and actually, you're talking about a
Don't
wet
we get us
easement,
an
it's
action?
not,
No, but
it's not part of the.
But we had to go through this in order to
Well,
get
that's fine, but
who owns which property, and the rights.
that's.
So we've had to get a new easement to move it
That the question is
into
not
a
being
correct
answered.
spot.
The question is not being answered is, I'm a little confused here in that, how the applicant can sign a contract for property that he doesn't own.
He owns the easement.
He owns,
All of the properties.
But does the easement give him right to
that's,
improve?
he does not
Yes.
own, he does not own the entire easement.
No one person owns the easement. The easement is granted as access to each individual property.
Right, so it seems to
Don't
me that
each
the contract would have to be signed by each individual person in order for the work to be done on their property.
No, because the easement itself, I won't get into the legal ends because I do this quite often. Have to work on easements and roadways through other people's properties. The person who is served by that easement can maintain and is responsible to maintain. Because otherwise, everybody would have to be responsible for their piece in front of, on the edge of their property where the easement goes through, thereby paying for that individual piece and be
That's-
responsible for
in
it.
any-
And it doesn't work that way.
And that's why in most situations, they have road maintenance agreements with the property owners, which in this case apparently it doesn't exist. I'm just trying to make a point as far as, you know, my question is, how can one individual on a roadway required by all the residents make a decision on that roadway without consulting, you know, the other residents? Anybody else have a question?
That's my report for questions.
Should, give Mr. Ashwell or, Nancy?
Well, yeah, I'll, can't go on forever here. Are there any other, and we'll come back to this. Is there anybody else that wants to, make a comment?
Yes, I'm Brian Schultz. I live in Parkway. I'll start by asking you to deny this SUP. The Hendersons have had their SUP revoked by the BZA. They know the rules well. Why reward bad behavior? The problems with 65 Clark Lane have gone on for almost 20 years. We have had 3 owners of 65 Clark Lane. They have a lot in common.
You speak up just a little bit,
Well,
basically.
the goal has been to monetize that property to the fullest. The first owner built the house with a single-family occupancy permit. Against the opposition of the neighbors, he operated an illegal B&B and more. He was convicted of this illegal operation. Knowing prior history, the second owners approached the neighbors individually and said they wanted to run a B&B, but would only do so with their support. They did not get that support. At that point, they made a full court press to get an SUP. They received a 3-bedroom SUP, but it was not enforced. When that fell apart, the Hendersons acquired 65 Clark Lane, knowing full well the past history and opposition against this opposition on this private lane. I repeat, private lane. The Hendersons have Crispy Ball, a brewery, a winery. How much more business do we need in Clark Lane? Please end this 20-year nightmare from 65 Clark Lane. Prior to a business there was never any problems with the road on Clark Lane. It was nice to work. It served the neighbors very well. We would run into neighbors, we would stop and talk with neighbors, we'd be our neighbors' friends. It was a very nice private lane. Another thing all of these owners have always said is how good they are for Rappahannock, how dollars turn over, how many people they employ, how great they are for the county. And to that I say, if they don't care about their neighbors, I really doubt they care much about the town, or the other people in the town. Thank you.
Any other questions? Yeah, please. There are seven residences on Park Lane, is that correct? Yeah, 7 residences. Are there any residents that support the activities? And
No, no,
Thank you. Okay, Mr. Ashwell, you have.
Thank you. I think one thing you need to remember, when Mr. Ford was making his comments, I think he was trying to advise you that the VDOT indeed had responded to the requirement back in 2013 about the need for a pull-out. That's what he was referencing in that letter about. That he had documentation that there was no need for it. So the fact that they eventually discontinued the use of that particular property, then my clients came and got the second request for it, but that's under condition only to remove it before the report came in saying he didn't need it. I don't know what they were thinking about when that happened. It may have been a choice made by their attorney or by something else entirely. But there are other businesses that are run out of homes on Clark Lane. So these aren't only commercial people, and if you know who I'm talking about, look at it. So other people run commercial type businesses out of Clark Lane. And the fact that, and we know there's no road maintenance rates. Well, this guy's ponying up the jack to fix the road for everyone. And now he's being vilified for that? Now, if he's gonna have to follow all the requirements that Mr. Curry will put up in that, permit, and we'll do that. Some trees that were planted improvidently will have to be removed, that's just part of the deal, and they're gonna get the road up to the best shape it can be, because it's not required to be a type one under your old ordinance. So, the road to the top of the hill is not an issue. The road at the bottom of the hill, 211, by VDOT's own concession, is not a problem. So, this application should be granted for all those reasons. He did say that he promised all these jobs. No one ever said that there's a lot of jobs generated by this, since it being, but there are economic benefits. There's a multiplier effect by the purchase of $1, makes the dollar go all the way up, Rappahannock County. That's a good thing. And I think the comprehensive plan tells us we need to.
I'll comment on what you're saying about the VDOT. And that, to my knowledge, VDOT does not make recommendations on private roads. VDOT's recommendations have been at the juncture of the private road with 211. That is where their authority and recommendation stop.
Mr. Chair, may I add to your comment now? Is that the VDOT, I think that was the September 17th, 2019, I believe, the letter sent over to Michelle Summers said, entrance is acceptable for up to 5-bedroom B&B, but nothing more. And there's a winery going on. And as the residents on Clark Lane, we don't like that road widened. We just like the road fixed.
They were public comment.
Can I ask a question?
Okay.
Now, you're saying that this letter that Yoko presented here with that says they want VDOT's approval for design with respect to their specifications, are saying this, somehow you think this is moot?
I don't think, you talked to me about saying, I didn't think they used the word moot in any conversation.
No, I said,
okay.
no, are you saying, they're saying, you're saying VDOT has totally, presenting it as if VDOT has no problems with the entrance as it is, and yet I see this, and I'm asking you to reconcile that for me.
Gladly. These are the minutes of Mr. McCarthy, erstwhile zoning administrator for Rappahannock County, and I wasn't present there, but if there was a requirement that VDOT give the up or down, thumbs up or thumbs down on this, that was a part of that particular application.
Right.
And you all, if you
Well,
want to,
it's the five
if I may answer your question,
Sure.
if you all want to make that an aspect of your approval, you had the right to do so, and apparently did. What we're talking about is a similar requirement that you all are, whether it was in the hands of the Board of Supervisors or BCA at the time, we don't know, to go back and forth. But his permit had a requirement that VDOT give the thumbs up or thumbs down, and he told us tonight, without objection, that he got a letter from them saying there's no need for any kind of change of.
Well, I'd like to see that letter, really, I mean, I just can't take a break.
You know, take everybody else.
Well, I mean, I haven't, actually. That's your shit.
Everything they say. The historical analysis is here saying, the fact that nobody else, does anybody else on Clark Lane approve this? Not that I know of, that's what, this is a quasi.
Mr. Chairman, he asked for the letter I can provide if I'm allowed to approach and offer what I said is true,
Mr. Whitman?
to answer his question.
What letter are you referring to?
The issue that was brought up about the 2013, the conditions that were attached, which she indicated had not been fulfilled, were in fact fulfilled. The first condition was that VDOT look at the entrance to see if any modifications were necessary. They did look, and they decided no modifications were necessary. That was point one, and this is what that is.
That's fine, we understand that.
Okay, and the second condition about pullouts, in fact, 3 pullouts were installed on that road. They've since overgrown because I no longer am there. So the things that she said did not happen. Both of them did, and both of those conditions were successfully filled. It was after I installed the pullouts that I unfortunately went through a divorce, and I decided to close the B&B and did not pursue it further. But the special use permit was still enforced. So I do have the written communication from VDOT saying that no modifications were necessary.
And I'm sure we have that in the record, we just don't have it in hand here. Thank you.
You don't need
Okay.
it.
Okay, there's no other public comment, I'm going to close the public hearing, and the board will now discuss what we want to do. We have any comments from, Seth, you want to start?
Yeah, sure. I'm looking at the provision that was cited by Mr. Ashko about it's RCC section 170. I'm sorry, it's RCC section 70-87, which has to do with private streets. And it says A, type 1, all types of development, and then Mr. Ashko cited section 1, private streets within a development shall be limited to those streets which are not required or designed to provide access to adjacent properties or the remainder of the tract being developed. However, if you look at B of that section, it says type 2, no private streets not built to type 1 standards shall serve more than 5 lots. And Park Lane serves more than 5 lots. So it seems to me that it's not in compliance.
Bill?
Now, we're being, we have a plan here, we're being asked to permit this, given the current state of the road, not the improved state of the road, based on some promissory thing about the road will be improved? Is this what we're saying?
I'm not allowed to answer, but there's a
Yeah, I'm
rhetorical
asking you
question.
a direct question. You're asking for us, for permission to do this based upon the promise of a road improvement which has not been made, and we have no way of enforcing that it's being made except to withhold permission until it is made. Am I correct in assuming that?
I respectfully disagree. Anytime a board issues a special use permit, it can, and we've seen it before where you put special conditions on an issuance of a special use permit, like Mr. Ford had to do. So it's not unheard of that a special use permit would have conditions that were by the board. He said, just now that it's a promise. It doesn't have to be
Well,
a
I mean, this
promise.
is a condition that you may have this road, and you're saying, okay, we'll make the road, so that's a condition. Now, are you saying we should accept that you say, okay, we'll do it as fulfillment of the condition, or do we use the road, the completion of the road as the fulfillment of the condition?
Anytime the board like this issues a special use permit, it can require certain conditions, as you've always done in the past and will continue to do in the future.
Right.
Should they not be fulfilled, it happens in the town, happens here, off here, where then you have a way to yank the permit. Because a condition, a reasonable condition set by the Board of Zoning Appeals is a reasonable condition unless we appeal it and the court tells us otherwise.
Right.
So it's not a promise. It's if it's a condition and we don't fulfill it, we don't keep our permit. Exactly what happened down here. So we don't need to promise anything. If you make it a condition by cracking,
I'm sorry.
we'll follow.
Okay, but we can put we're permitted to have conditions, and one of the conditions could be, you're saying, that the road be up to par before the permit is granted.
I would love for you to use the term up to par. I think you're going to need to use something more that Ms. Ritter perhaps suggested, in order for us to be able to fulfill an obligation that the county requires of its BZA.
Well, up to whatever the standards are.
Whatever you all
Existing
say.
standards, but our
Whatever you,
standards.
whatever you say in the granting, if you were to grant this, would be what the condition would be. We would
So
look
the
at it.
condition could be that the road is completed before the permits, that you're saying that that's, okay.
Yeah, you
That's our-
all.
That's all right, that's our
something
call,
else.
but you're, yeah, okay.
I'm not necessarily agreeing with that, just saying.
Well, I understand that, I'm just saying if you wanted, yes, okay.
Gary, any comments, questions? Okay, I have no further comments. At this point in time, maybe we should go through the general standards.
Mr. Macklow, you
Yes, sir.
afford me the opportunity to clarify the record.
Yes.
Testimony, or whatever you want to call it, is given. Much of what Mr. Capielli said to you is not factual, and I'd be happy to have records to produce to substantiate what he said. Rappahannock County Code, Chapter 98, right at the beginning, identifies the memorandum of understanding between Rappahannock County and the Culpeper Soil and Water Conservation District. There is an agreement. We are the permitting authority, and the permits must come from us. Applications must be submitted to us, and then we pass them to our contractor for review. Nobody told him he couldn't talk with other people, and I'm aware of no record that suggests Ms. Summers said nothing could be approved until she said it was okay. We did say interim submittals straight to the Soil and Water Conservation District and not to the permitting authority aren't useful. If you want to submit multiple iterations, submit them to the approval authority, and we will pass them to our contractor. But they were bypassing that process and going straight to Mr. Jacobs, as Mr. Capielli said.
Okay, general standards. Basically, we have to agree, majority agreement on all the standards in order to make it work. So we'll start at 170-52 General Standard A. The proposed use shall be such that it will not adversely affect the use or development of neighboring properties and shall be in accordance with the applicable zoning district regulations. The location, size, and height of building structures, walls, and fences, and the nature and extent of screening, buffering, and landscaping shall be such that the use will not hinder or discourage the appropriate development and or use of adjacent or nearby land and or buildings, or impair the value thereof. So, basically, we need to be in agreement with the majority as far as whether the permit would satisfy the standard.
I don't think so.
Karen?
I don't think so.
Edwin?
So I can't hear anybody what they're saying.
Okay.
No.
No, no, no,
No,
and no. So, first one is no. Okay, B, the proposed use shall be such that pedestrian and vehicular traffic generated will not be hazardous or conflict with the existing and anticipated traffic in the neighborhood and on the streets serving the site.
no,
No.
No. Adequate utility drainage, parking, loading, and other necessary facilities to serve the proposed use shall be provided. Parking and loading requirements shall be in accordance with the provisions of Article 9 and 10 of the Rappahannock Code.
I'd have to read 9.
yes, I think they need,
You think what?
I think they need that.
Okay, and I think. Signs shall be regulated by the provision of Article 12, except as may be qualified in the subsection that follows for a particular category or use. However, the BZA and the board and its authority represented, authority presented in 170-53 below may impose more restrictive standards for given use than those set forth in this chapter.
I think they probably meet that requirement.
All agree with
You're
that?
willing to meet those standards.
Could the chairman tell us how the, I saw one thumbs up, which I think is a good vote.
This is
And
a
I did
consensus,
hear
this is
he
basically a
said,
consensus.
okay, if you just announce that for the
Yeah,
record.
yeah, this is a consensus. E, the future impact of the proposed use shall be considered and addressed in establishing a time limit on permanent, existing and recent development, current zoning, and the comprehensive plan shall be among the factors used in assessing the future impact of the proposed use and whether reconsideration of the permit after a stated period of time would be necessary and appropriate for protection of the properties in the vicinity to ensure the implementation of the comprehensive plan. Yeah,
Well, we're certainly thinking about the future impact, and we've taken into account existing and recent development and current zoning and comprehensive plan, and the future impact of the proposed use. But since I'm guessing we're not going to issue a permit, there should be no issue about reconsideration.
if the permit was issued, though, we would want reconsideration. You agree with that?
Thanks, you tipped your hand.
F, the proposed use shall be such that air quality and surface and groundwater quality and quantity are not degraded or depleted to an extent that would hinder or discourage the appropriate development and or use of adjacent or nearby land and or buildings or impair the value thereof.
I think that standard is met.
I think that's no problem there, the drainage, it's not an issue of the property. Okay, G, the proposed use will not result in unsafe conditions in relationship, or in relation to community facilities. Existing or plan is related to adequate police and fire protection and danger and congestion in travel and rescue services. The road could be considered as the present exists, but they could get up it.
Yeah.
So,
I think they meet that standard.
yeah, it's good. I agree with that. H, the proposed use will not cause an undue impact on the sanitary landfill and solid waste transfer collection station. I'll go with that. The proposed use will not cause an undue impact on the historic or scenic qualities of the area.
I think it will.
And J, the proposed special exemption will not be detrimental to the implementation of the adopted comprehensive plan, including the goals contained therein. And this I'll read principle 7, which is the principle that we consider at this point, which says to promote only economic growth that assists in maintaining our existing balance and is compatible with the environmental quality and the rural character and does not adversely affect active farm operations, forestry operations, residential neighborhoods, the tourist industry, and the county's fiscal stability.
I think that provision has been met.
Has been met,
Yes.
and it will not affect the neighborhoods.
I think it affects the neighbors.
And it will not be detrimental to the implementation of the adopted community plan.
I'm
You
sorry.
don't talk about it further on that, then you don't.
Okay, well, you know, that, okay,
It's
no
like,
problem.
I think it would adversely affect the neighbor.
I think it will adversely affect the neighborhood.
I happen to agree.
If I had to meet each of the criteria, then it does not. It would adversely affect the neighborhood. I appreciated the argument for agritourism, so, I'm torn on that one, but I don't think it needs to be part of it, if they all be satisfied.
appears that, going through the general standards, that, we have sufficient, information to not affirm that it's the one that's going to. We have a motion.
Are you going to look at the special conditions as well in 17066K?
At this point, no, because I think we have grounds to deny the permit. And that was what we were,
The special conditions become moot at that point?
Well, I think if they can't meet certain of those, that is also important. Or if they can meet all of those, that might be important as well.
Could you speak up just a little bit?
I think they're germane to the application.
You can take a look at those.
There's a motion on the table.
There is a motion on the table, yes. But we're, we can,
I withdraw the motion until we check this out.
see if I can find the staff report. There we go. Okay, Mr. Curry, I'm not exactly sure which part of the staff recommendations you're.
I'm just talking about 17066K, which is the special requirements for B&Bs and tourist homes.
Additional standards for tourist homes and bed and breakfast.
Oh, okay.
Such use may, such a use may provide accommodations for not more than 10 transient occupants and in not more than 5 rooms classified as lodging units.
All right, oh, you're on K then, right? 17666K. Okay, yes, so that's a requirement that we, I don't know how we make a determination on that one. I'll just run through them then. Off-street parking shall be in accordance with provisions of Article 9, shall not be located in any required courtyard, shall be effectively screened. That would be a condition we could put on there. In residential resource preservation districts, any buildings to be constructed shall not be more than 2 stories, and have exterior appearance of a single-family residence and normal residential accessory structures. This is in agriculture. In A and C zones, the minimum acreage requirement for tourist homes and preference shall be 10 acres and 20 acres, provided however that the BZA can waive the minimum acreage required only if the property has frontage on a paved public road that is part of the state primary or secondary system. Bed and breakfast and tourist homes shall be authorized to serve meals only in numbers equivalent to the approved number of overnight accommodations. The private road or public roads other than primary or state secondary roads serving tourist homes and bed and breakfast shall meet the standards for type 2 roads in 170-86 and 170-87, and is shown in Appendix A of the Rappahannock County Subdivision Ordinance, Chapter 147 and 147-54. That is a condition at this point in time that is not met. I think we're agreed on that. The issuance by the zoning administrator of a special use permit shall be conditioned upon the applicant obtaining any license that may be required by 12 VAC 5-431-180 and furnishing evidence that the proposed use proposed use meets all applicable state and local health requirements. That's dealt with by the health department. Issuance of special permit shall be conditioned upon the applicant obtaining a VDOT entrance permit as required by the road design manual and other applicable state law or regulations. That is an issue that we've discussed, but the actual entrance to the property is not on a state road. The BZA or board may import, this is the one we talked about earlier, board may impose additional appropriate conditions to ensure that the permitted use shall not generate noise, vibration, glare, noise, or other effects that unreasonably interfere with any adjoining landowner's enjoyment of his property or residence, including but not limited to. The maximum number of adults permitted at any one time shall not exceed twice the number of lodging units. We discussed that earlier, and that if we were to entertain a motion to approve it, that would be part of the application because it has been requested by the county. The other one has to do with lodging being notified. The operator shall post and provide residents with the emergency fire extinguishers and full alarms, functioning smoke and fire detection. The operator shall provide evidence that no less than $500,000 of liability insurance cover with limited residential lodging use, or that each limited residential lodging use is conducted through a hosting platform that provides equal or greater coverage for such use. And that, there again, those are, that one, if we were to, have a motion to approve, we would go through this list and attach conditions that are on the list, which ones we feel are appropriate. So, having said that, I will go back to looking for a motion on the application.
I think that just reinforced what we're saying. I agree with you.
I hear a second? A motion second. Go on a roll call vote. Sharon? Andy?
No.
Bill? And Bill? The application's denied.
The motion was to deny the permit and you just defeated the motion.
Say what?
The motion was to deny the permit and you defeated the motion unanimously.
The motion was to deny it, so it should have been yes.
We have a
I don't know. You've taken no action at this point.
It's not in the meeting.
The motion is to deny the permit.
I appreciate it, but
Say yes.
don't do them any
In
favor.
order to deny it, they can't say no.
Okay.
Let's take the vote.
Anything's confusing.
You have to vote in affirmative for
Okay.
some motion.
Okay, because the motion at this point was actually, what was it?
Defective.
This is all.
The motion was to deny the permit.
Right.
So
So
the
we're-
second is,
Yes, we were.
yes.
So
So
we're going
confirm
to,
the motion.
I will entertain a motion at this point to reconsider the motion.
So moved.
Second. All in favor?
Aye.
Okay. I will now entertain a motion.
I would that we deny the permit.
Yes.
There's a motion seconded. All in favor of denial of the permit?
Aye.
Aye. It's unanimous. Sorry, pardon us for the,
Anything else, Gary, before we leave?
we're not professionals. We do our best.
I need
Had it for 5
What?
seconds.